The U.S. Supreme Court has rejected President Donald Trump's request to throw out a $5 million jury verdict, finding him liable for sexually abusing E. Jean Carroll and later defaming her. The legal battle stems from a 1996 encounter. Carroll, a longtime advice columnist, testified that Trump trapped her in a New York City dressing room, turning a friendly encounter into a violent assault. Trump fiercely denied the attack in 2022, slamming the allegation as a total hoax. But that defensive move backfired when the jury found him liable for defamation. Trump's lawyers had argued that allegations leading to the $5 million verdict were propped up by highly inflammatory evidentiary rulings, including those that allowed the testimony of two other women who accused Trump of sexual abuse decades ago. Trump has denied all three women's allegations. His attorneys also argued that the judge broke federal evidence rules in the case and framed it as a distraction from Trump's unique duties as president, though the verdict came before his return to the White House. Carroll's lawyers had urged the justices to pass on the case, saying the women's testimonies were relevant because the allegations were similar and that the judge's decisions were in line with others around the country. The Supreme Court decision to not take up the case comes as the High Court hands down some of the biggest decisions of the term, many of which directly impact Trump's agenda.
Donald Trump appears to be running out of legal options in his effort to delay paying E. Jean Carroll. A jury found Trump liable for sexually abusing and defaming Carroll and awarded her approximately $5 million. Trump appealed the verdict, but the appellate court upheld it. He then asked the Supreme Court to review the case and overturn the judgment. The Supreme Court refused to hear his appeal. That decision left the jury's verdict in place and closed what was likely Trump's final realistic path to reversing the judgment. But instead of allowing the money to be released, Trump's legal team made another request for more time. Their latest argument is that Trump has hired a new lawyer who needs time to study the case. They may also ask the Supreme Court to reconsider its refusal to hear the appeal. The problem is that there is very little left to litigate.
Okay, we're back now with a legal blow for President Trump in federal court. A judge ordering that writer E. Jean Carroll should immediately receive the more than $5 billion she's owed after a jury found President Trump liable for sexual abuse and defamation. That order coming despite the president's demand for a delay. NBC News legal analyst Danny Savalos joins us now. So, Danny, the president's legal team filed another appeal minutes after the judge's order. Is there a real shot of blocking the payment, or is this a game plan just to kind of delay?
No, not really. In all likelihood, I should say that the odds of getting any kind of reconsideration at the Supreme Court or any relief at the district court are next to none. Trump's argument is essentially, yes, we agreed if cert was denied, if the Supreme Court denied to hear my case, that would be it. The funds would be released. But technically, as long as we're still asking the High Court to reconsider, as long as we're still fighting, this appeal is still live, and therefore the funds should not be released from escrow.
And then on that point, Carroll is owed more money for another case against the president. Will that cash be held up in appeals too?
In all likelihood, probably not. And I say that because the Trump team is making some creative last-minute arguments, but their arguments really amount to saying after a court essentially gives a final order. Because here, this has been the rule for centuries now. Once your case gets to the Supreme Court, they either deny your opportunity to be heard, called denying cert, or they choose to hear it. But either way, if they deny cert, that is the end of the case.
Trump has already received a jury trial, an appellate review, and an opportunity to seek Supreme Court intervention. He lost at every major stage. Asking the Supreme Court to reconsider is technically possible, but such requests are rarely successful. The justices would have to revisit a decision they had only recently made and conclude that they should have accepted the case after all. Judge Lewis Kaplan, who presides over Carroll's cases against Trump, does not appear willing to permit an open-ended delay. Instead, Kaplan placed Trump's legal team on an expedited schedule. Trump's lawyers were ordered to explain why the court should not immediately release the secured judgment funds. Carroll's attorneys would then receive a short period to respond before the judge issued another decision. The original judgment was around $5 million, but interest continued to accumulate while Trump pursued his appeals. According to the decision, the amount had grown to approximately $5.8 million.
Trump's team is saying, well, technically the court could decide to reconsider its own decision not to hear this case. So technically, all this stuff is still alive. It's sort of part of the Trump playbook of legally fight until the bitter end, which, is either a bug or a feature, depending on how you look at it.
Okay, Danny Savalas for us from London tonight. Danny.
This is an important part of the case. Trump's delaying strategy did not eliminate the judgment. It increased the amount he could ultimately be required to pay. Trump also cannot simply refuse to hand over the money once his legal challenges end. When someone appeals a large financial judgment, courts normally require the amount to be secure. This can be done through cash deposited into a court-controlled account, an appeal bond, property, or a guarantee from a surety company. The system prevents a losing defendant from appealing for years, moving or spending available assets, and then claiming there is nothing left to collect.
Tonight, a federal judge has ordered E. Jean Carroll to be paid $5 million after a jury found President Trump sexually abused and defamed her. The Supreme Court recently let the 2023 civil verdict stand. The president's lawyers had immediately appealed to stop the payment and said they would continue to challenge the verdicts. They also accused his political opponents of using the legal system against him.
In Carroll's smaller case, the money was reportedly secured during the appellate process. That means Judge Kaplan may be able to authorize payment directly from the secure funds without needing Trump to cooperate personally. If Kaplan rejects Trump's final request for more time, Carroll could soon receive the original award plus accumulated interest. But the $5 million judgment is only one part of Trump's legal problem.
I do want to take you out to some breaking news that we are following at this hour, as a federal appeals court has now upheld a $5 million verdict that E. Jean Carroll won against Donald Trump when a jury found the U.S. president-elect liable for sexually abusing and later defaming the former magazine columnist. The decision was issued by a 3-judge panel of the Second U.S. Circuit Court of Appeals in Manhattan, and all of this information here is coming in from Reuters. Now, the May 2023 verdict stemmed from an incident around 1996 in a Bergdorf Goodman department store. It was in a dressing room there in Manhattan where Carroll said Trump raped her. And an October 2022 Truth Social post where Trump denied Carroll's claim as a hoax. Though jurors in federal court in Manhattan did not find that Trump committed rape, they awarded the former Elle magazine advice columnist $2.02 million for sexual assault and $2.98 million for defamation. A different jury ordered Trump in January to pay Carroll $83.3 million for defaming her and damaging her reputation in June 2019 when he first denied her rape claim. In both denials, Trump said he did not know Carroll. She was, quote, not my type, and that she fabricated the rape claim to promote her memoir. He's appealing the $83.3 million verdict as well. Carroll's cases are continuing despite Trump's having won a second 4-year White House term. That, of course, happening back on November 5th, and he is expected to take office January 20th.
Carroll also won a separate $83.3 million defamation judgment against him. Trump is appealing that verdict, and his attorneys are expected to raise several arguments similar to those that fell in the smaller case. The two lawsuits involve the same plaintiff, the same defendant, and the same federal judge. They also contain overlapping disputes about evidence and witness testimony.
In 1997, in a case involving former President Bill Clinton, the U.S. Supreme Court ruled unanimously that sitting presidents have no immunity from civil litigation in federal court over actions that predate and are unrelated to their official duties as president. Trump's lawyers did argue the $5 million verdict should be thrown out because the trial judge should not have let jurors hear testimony from two other women who accused Trump of sexual misconduct. One, businesswoman Jessica Lead, said Trump groped her on a plane in the late 1970s. The other, former People magazine writer Natasha Steinoff, said that Trump forcibly kissed her at his Mar-a-Lago estate in 2005. Trump's lawyers also said the trial judge should not have let jurors watch a 2005 Access Hollywood video where Trump boasted graphically about forcing himself on women. Both trials were overseen by U.S. District Judge Lewis Kaplan. Again, this just coming in from Reuters right now, as we are learning that a federal appeals court has now upheld a $5 million verdict that E. Jean Carroll won against Trump when a jury found the U.S. president-elect liable for sexually abusing and later defaming the former magazine columnist. Normally in a situation like this, we would hear from Trump on Truth Social, so we'll keep an eye on that social media platform and bring you his reaction here on Live Now from Fox.
One major issue involved with Kaplan's decision to allow two other women to testify about allegations involving Trump. His attorneys argue that their testimony should not have been admitted. The appellate court rejected that argument in the smaller case, and the Supreme Court declined to review it. Similar questions may appear in the appeal of the $83.3 million verdict. That does not guarantee that Trump will lose the larger case, but the outcome of the smaller appeal makes his position more difficult. Interest is also accumulating on the larger judgment. Depending on how long the appeals process continues, Trump's total obligation could rise significantly above the original $83.3 million award.
We begin with breaking news in one of Donald Trump's legal cases. Just moments ago, NBC News learned Donald Trump has posted a bond of over $91 million in the E. Jean Carroll case just days before it was due on Monday.
Let's get NBC legal analysts Glenn Kirshner and our correspondent Lisa Rubin on the phone. Lisa, first, what do we know? What can you report?
This morning, Alina Habba, who was one of Trump's lawyers and indeed the lead lawyer in the E. Jean Carroll case, filed a motion with the court to post a bond in the amount of $91 million and $630,000 as well. That represents the total amount that would be required to obtain a stay pending appeal in this case. The judgment, as you will recall, was $83.3 million. Usually, a defendant has to post more than 100% of that to obtain the security necessary to protect the person who won as the case goes through appeal. But at this point, what Trump has done by posting this bond is to prevent E. Jean Carroll from taking any steps to collect that judgment from him, because it is essentially going to be in an escrow account for her protection as he pursues his appeal of the judgment in this case.
That judgment has also been secured so Trump can pursue his appeal. The security may involve a bond, a surety company, cash, property, or another financial guarantee. Whatever method was used, its purpose is to ensure Carroll can collect if Trump loses. Trump may continue filing motions and searching for new procedural arguments, but delay is not the same as victory.
We're going to start this hour with that breaking news. Former President Donald Trump just testified in his own defense in the defamation trial brought against him by writer E. Jean Carroll. Mr. Trump answered only a few questions in front of the jury. Carroll is seeking millions of dollars in damages. The jury is tasked with deciding how much the former president should pay Carroll over defaming her when he accused the writer of making up a sexual abuse claim against him back in 2019. This is just one of many legal cases Trump is facing as he tries to win back the White House. Today's case is all about the civil defamation case brought by Carroll. Last year, in a separate civil trial, a different jury found Trump liable for sexually abusing and defaming her. Mr. Trump has repeatedly denied her accusations. Joining me now to dig into this, NBC News correspondent Rahima Ellis and NBC News legal analyst Angela Senadella. So, Rahima, let's start with you. I understand former President Trump just left the courthouse, not visible to reporters, but walk us through his testimony today.
According to our reporters and producers in the courtroom, when we take you inside that courtroom, they said it was incredibly tense in there. Prior to Mr. Trump taking the stand, the judge had asked his attorney to offer a proffer, if you will. That is basically, tell us what your client is going to say. Tell me what the questions are. At one point, while this is going on, Mr. Trump says, I don't know who this woman is. I have never met this woman. At that point, the judge admonishes him, telling him to keep your voice down, Mr. Trump. You are interrupting these proceedings while your counsel is talking, and that is not allowed. Remember, this is happening before the jury has come back into the courtroom. This is just the judge and the defendant and E. Jean Carroll and their attorneys. It was tense. And he was told, there were questions, she was told there were questions you can ask, you can't ask. By my account, it was 4 minutes by the time he took the stand to the time he got off the stand. Others are saying it was only 3 minutes. There were only, as you point out, a couple of questions asked. One was, have you viewed your deposition? Yes. You stand by it? 100%. Do you deny the allegations to defend yourself? Yes. I consider it a false accusation. At that point, he's now on the stand being questioned by his attorney. The judge chimes in, it is stricken. In other words, the jurors are not to consider his response of, I consider it a false accusation, as we pointed out.
Decision.
He's already determined that this is true. And then on cross-examination, he's asked about whether or not the deposition occurred back in October 2022. That was very formal. Next thing you know,
the jury ruled against him. The appellate court upheld the verdict. The Supreme Court refused to intervene. The money has been secured, interest has grown, and Judge Kaplan is now deciding whether the funds should finally be released. The immediate question is no longer whether Trump can permanently avoid the smaller judgment. It is how soon E. Jean Carroll will receive the money, and whether the much larger $83.3 million judgment will eventually follow the same path.